you all for joining, and for joining on time. Um, we're gonna get started here. And if you've been to any of these workshops before, you've probably heard me say this. I'm a mortgage guy, right? And I put people in debt. And I always think, man, I give people the biggest debt of their lives. So one thing that I try to do is try to figure out creative ways or useful ways that I can help you be in a better financial position. So we do these types of workshops, right? Where we bring financial advisors to talk about how to retire faster. We bring tax preparers to talk about those tax loopholes. And this is one of my favorite topics. Today, Alex is going to be talking to us about estate planning. And this is one of the tools that rich people use to like really level up. And the crazy thing is, like for our culture, at least for like my family, nobody talked to us about this, right? So what I try to do, just because of my background, I don't know if y'all know this, but I was raised by a single mom, and she was raising two kids, trying to figure it out, and she didn't even speak English well. So somehow she figured it out, and we turned out okay. But I always used to think, man, we're always struggling financially. When I get older, I'm gonna figure out like the rules and the tricks that the rich people use to like get wealthy, and I'm gonna teach it to people. So now what I do is I bring the smartest people that I can find in order to teach my family, my friends, my clients how to be in better financial positions. So today I'm super excited to have Alex Varela here from the Wagon Legacy. I actually met Alex through a mutual friend, and she did a workshop like this. And when I saw her, I said, wow, finally a lawyer that doesn't put everyone to sleep. So I asked her immediately, like, we got to get together. I'm setting the bar really, really high for you here, Alex. But I'm
Yes, you
super
are.
excited to have her here because she's amazing. She's going to talk to us about a something that's super important to have, and I'm excited for everyone to learn. So I'm going to hand it over to Alex. If you do have questions, put it in the chat. And if you need anything from me, you know I'm always here. And thank you all for coming and investing in yourself. What we learn, no one can ever take away from us. So I'm going to hand it over to Alex, and we'll be here for any questions. Alex, it's all yours.
Yeah, absolutely, Armando. Thank you so much for having me. I sincerely appreciate it. And thank you all so much for joining. As Armando mentioned, my name is Alex. I'm a local trust attorney and I own an estate planning law firm. And before we jump in, I would love to just tell you a little bit about myself and about my practice. So we're a team of about 12 people, 3 attorneys, and really my goals for the team are communication. These are our core values: helping clients make informed decisions, staying in touch with clients, being there for our clients' families when they need us. I've sat across the table from so many clients and I've told them, when you become incapacitated or you pass away, I'm going to be there for your kids. So now I do just that. And we do what's best for our clients every single time. I'm really blessed, humbled, honored by the more than 300 5-star reviews that we have online. So truly amazing. But this is for you tonight if you've received misinformation or conflicting advice about estate planning, if you're worried about leaving a mess for your kids or your family, if you're worried about protecting your assets from immature beneficiaries, or if you just want to make sure that what you want to happen will actually happen when you pass away, if you become incapacitated, or if you need long-term care, then those are all topics that we're going to cover tonight. So you're in the right place. But again, before jumping in, I would like to just share my passion or my heart for estate planning, why I became an estate planning attorney. And it is because of my grandmother, Josefina. My grandparents came to this country from Cuba about 50 years ago. They managed to buy a little house here in Southern California, and they paid $12,000 for the house 50 years ago. It appreciated quite a bit in value, obviously, but my grandparents never had a will or a trust or any form of an estate plan, really. And my dad and his sister had quite a bit of conflict over how to take care of my grandmother, how much to prolong her life, and then what would happen with the house. Unfortunately, my grandmother passed away some time ago, but my dad and his sister went a long period of time without speaking. And then right at the onset of COVID, my dad's sister, my aunt, passed away prematurely, and it had been about 10 years or so since my dad or myself had spoken to her. Not something that I'm proud of, not something that my dad is proud of, but obviously not something that I can go back and fix or change. So now what I try to do with the practice, or the heart behind the firm, is really to avoid that type of conflict and turmoil in other families and try to help my clients make decisions that are going to promote harmony in their own family rather than cause division. My husband Steve and I have been married for 17 years, and we have 3 kids who are my everything and my inspiration for everything. For 2 years, I taught an estate planning class at Cal State Fullerton, and I loved doing that a lot to run a practice and 3 kids and teach. So I'm taking a break from the teaching, but I love that experience. And go Titans if there's any Titans on the call tonight. But what is it that we're going to cover tonight? So we're going to cover what is estate planning and who needs it? What are the biggest mistakes that I've seen over the last 10 years or so, and how do we avoid them? And then in that, we're going to talk about probate. We're going to talk about protecting our children's inheritance or our beneficiaries' inheritance from lawsuits, creditors, and divorce. We're going to talk about planning for incapacity and the ways that we can ensure that we leave a lasting legacy. And then I love real examples and stories, so I'm going to try to do as much of that tonight as possible. So what is estate planning? I love this definition because it sums it up beautifully in one sentence. It says, I want to provide for myself and my loved ones during my lifetime, and upon my incapacity or death, give what I have to who I want, the way I want, when I want, and if I can, save every last fee, tax, or court costs possible. So again, one sentence that sums up what we're talking about and what the goal truly is. So many folks come to my office and they're thinking primarily about real estate when they think about what is in their estate. But I challenge clients to really think about everything that they have, because we want a comprehensive plan. So of course, real estate, timeshares, bank accounts, investment accounts, brokerage accounts, stock accounts, retirement accounts, life insurance, business interest. And then you'll note that I skipped over a personal property, because almost every client tells me that their kids won't care about what they have, their personal property, their jewelry, or their furniture. And then in almost every trust administration case, there's some conflict about something like that. That's really hard to divide into 2 or 3, like a ring. So I even challenge clients to plan for all of that so we can minimize as much conflict as possible. And then who needs estate planning? Armando was sharing some of the celebrity estate planning trivia, right? But you don't have to be a celebrity, ultra wealthy, or have a complicated estate to need estate planning. I love what this says from a book called Money Education that I was using while teaching at Cal State Fullerton. It says, estate planning is for every husband, wife, mother, father, grandparent, business owner, or anyone who has someone they care about, are concerned about providing responsibly for their own well-being or for the well-being of those they love, their children or family, or for anyone who seeks to make a difference in the lives of others after they're gone. And I've had numerous probate cases, for example, where there was no estate plan and the kids would have loved to keep the house, but because of all of the fees, all of the costs and the complications, they were not able to. And that was the only thing in the estate. So I often tell clients that I feel like the less that you have, the more important it is that you plan, because we want to make sure as much of that as possible goes to your beneficiaries and doesn't go to attorneys or the IRS or other fees and cost. So as promised, what we're going to cover tonight is the 10 biggest estate planning mistakes that I've seen and how we can avoid them, starting with mistake number 1. And so mistake number 1 is dying intestate. And I tell clients that if you don't have a plan, then the state of California has a plan for your family, but you're probably not going to like it very much because it involves all of these things. So attorney's fees, appraiser fees, executor fees, bond premiums, filing fees, creditors, and it's a very slow process. And some of you likely know what it is. It's called probate. And so probate in Southern California right now, on average, is taking about 2 to 3 years. The assets are frozen during that time. It's incredibly stressful for families. It's public and it is expensive. So probate is really a breeding ground for conflict in families because of these things. Anytime with any relationship, really, if it takes a long time, if it's really stressful, if it's really expensive, it's not going to be good for relationships, especially not brothers and sisters who have never done business together before in their lives. To give you an idea of how expensive it is, probate costs about 5% of the fair market value of the assets. So if someone has a home worth $800,000 and an investment property or bank account worth $100,000, Their total probatable estate would be 900,000, and then probate is going to cost about 5% of that. So about $45,000. And note that the home might still have a mortgage, but we use the fair market value. So even if this home still had a $400,000 mortgage, to come up with the probate fees and cost, we're going to use the $800,000 number. Mistake number 2 is dying with just a will. And the key reason why is because a will not avoid probate. So I tell clients that a will is kind of like a letter that you write to the judge, who you want to be in charge of your estate, who you want your assets to go to. But it still has to go through that court process, because when you only have a will, all of your assets still stay in your name. My practice is called the wagon legacy, and it's called the wagon legacy because I tell clients, if you don't have a trust or if you don't have a plan, it's kind of like you're carrying all of your assets in the palm of your hand like this. Something happens to you, and it's kind of like you tripped and you fell and everything flies all over the place, and your loved ones have to go by trying to pick up every account, every life insurance, 401k, and find it all. And often in that process, they don't. And assets end up right here in the California Department of Unclaimed Property. And that's why if you Google California Department of Unclaimed Property, how much, you'll see that there's almost $12 billion in the California Department of Unclaimed Property. And it's actually gone up since I Googled and screenshotted this, because this was a couple years ago. When you have a trust in place, when you have a plan, instead of carrying your assets in the palm of your hand like this, it's as if you have this little red wagon and you're pulling it by the handle while you're alive and well. If something happens to you, it's like you tripped, you fell, you dropped the handle, and then someone that you know and trust comes and picks it up and continues to pull. But all of your assets stay inside of a little red wagon. So many clients know that a trust is important, and many people will come in and say, Alex, I'm so happy I'm finally doing this. I've been putting it off for years, right? But I like clients to know what a trust actually is. And it's actually quite simple. It's just an agreement or a contract between the trustor and the trustee, and it's for the benefit of the beneficiaries. So the trustor owns the wagon and everything in it. The trustee is pulling by the handle, and the beneficiaries are standing around the wagon like this. But while my clients are alive and well, and we'll use my husband and I, for example, while we're alive and well, we play all 3 roles. So we own the wagon, we're the trustors, we're managing all of our own assets. So we're pulling the wagon, we're the trustees, and then we're also the beneficiaries while we're alive. Nothing changes until incapacity or death. At incapacity, my brother, for example, has to pull the wagon for us, make sure that our bills are paid and make sure our kids have what they need. And then at death, again, we can no longer pull the wagon. So my brother is going to pull the wagon, manage the assets, and then he's going to distribute the assets to the beneficiaries. That's when the kids would become the beneficiaries. There are revocable and there are irrevocable trust. And for the purposes of tonight's presentation, we're talking about revocable trust because that is what a majority of Americans have. Sometimes Americans will, or folks will have an irrevocable trust, but it's usually for a very specific reason, because it's not as flexible in that we cannot revoke it or amend it after we set it up. One of the reasons that we help clients in the office with an irrevocable trust is when they're interested in qualifying for Medi-Cal, or when they need to qualify for Medi-Cal. And we're going to touch just briefly tonight on the difference between Medicare and Medi-Cal and why that might be important. But essentially, when they want to have assets not count against them for qualification purposes for Medi-Cal, we might set up an irrevocable trust. Or folks might need an irrevocable trust when they're over the estate tax exemption. So the estate tax is how much you can leave to your beneficiaries without paying a 40% estate tax or death tax. And right now it is 13.9 million, meaning that all of us on this call, for example, tonight, have an imaginary coupon for 13.9 million. Isn't that nice? But that just means how much you get to leave to your beneficiaries without your beneficiaries having to pay that 40% tax. When folks are close to or over that estate tax exemption, they might set up an irrevocable trust to remove some of the assets or the appreciation of assets from their estate. So actually the first question, Armando's first trivia question tonight was about Prince. And that is correct. In 2016, Prince passed away and he had no plan and his estate was way over the estate tax exemption. So his estate between fees and taxes, because of that 40% tax, the estate paid $87 million in fees and taxes. And a lot of that could have been avoided by having a plan in place. Now, of course, Prince, his plan would have been a little bit more complicated than my plan or perhaps your plan because he had a very large estate. So he needed a revocable trust and probably multiple irrevocable trust if he was going to try to avoid that 40% tax for his family. But unfortunately, he didn't do anything. And then that left his family in a pretty negative spot or situation. But the key benefit of a trust is that we get to avoid probate. So as we were talking about earlier, what probate costs is 5% in the fair market value of the assets. If this person, the same person with a house and an account, had a trust and the trust was done correctly and the assets were in the trust, this would cost $2,000 or $3,000, even with an attorney's help, to administer the trust. And then instead of taking 2 to 3 years, it would take 2 to 3 months because we can do most things with the death certificate. So makes a big difference when it comes to cost and to time. And then mistake number 3 is not funding a trust properly. And this is probably the biggest mistake that I see for people that do have a trust. They did take the step, but unfortunately, they didn't do it all the way, unfortunately. So whenever we talk about funding a trust, we're talking about the process of retitling assets in the name of the trust. So our real property goes in the name of the trust. Our bank accounts, like checking and savings, will typically be in the name of the trust. If we have an LLC, a corporation, those will typically be owned by the trust. So for example, my business is called Varela Law, doing business as the Wagon Legacy. But Varela Law, if you look at the stock certificate, it doesn't say Alex Varela. It says the Varela Family Trust. My bank account still says Varela Law. Legal documents, leases, things of that nature, they all say Varela Law, but Varela Law is owned by the Varela Family Trust. If we don't take those steps, then it's like we don't have a trust. We can shred it. It doesn't mean anything because our family is still going to have to go through probate. Years ago, I met with a woman named Cindy, and Cindy told me that she did not have a relationship with her daughter, and she wanted to leave everything to her nephew who was caring for her. Everything, or her estate, was 2 properties and about $350,000 in cash. I explained the process of setting up a trust to Cindy, and she said that her nephew was really, really smart and that she thought that he could probably help her do it online so that she can save some money rather than working with an attorney or with my office. I warned her about some of the issues with respect to doing it that way, but ultimately told her if that's what you want to do, that's totally fine. And if you need my help with anything, please come back and I'd be honored to help you. I never heard from Cindy again, but a few years later, I did hear from her nephew. He let me know that Cindy had passed away and he needed help getting the assets from her name to his name. So, and he did bring me a legal Zoom trust and it was signed and notarized. The problem is that Cindy's accounts were not in the name of the trust. She didn't have a beneficiary on the accounts, and then the properties were still in her name. So one of the questions that I asked him was, okay, well, did she sign a pour over will? And a pour over will just says, hey, judge, if I left anything outside of my trust on accident, I want you to pour it into my trust. So it's a plan B, and it's something that most trust attorneys, or like myself for sure, every time I do a trust, I always do a pour over will because I never know what clients are going to own down the road or if they're going to do it right or what have you. So he said, no, Alex, we didn't click pour over will. We only clicked trust when we ordered it on LegalZoom because I had no idea that you needed both. And that was a big mistake because had she had a pour over will, it would have poured the assets into the trust, and the trust said that everything went to him and the trust was properly executed. So that would have been a huge help. Instead, a probate had to be opened. And of course, the court required that Cindy's daughter get notice. Cindy hired an attorney, and the attorney argued that it was not a valid trust because it was not funded with assets. And I do probate trust administration, and estate planning. But for the probate and the trust administration, I don't do litigation. So when parties, I try my very, very best to keep parties on the same page and to keep siblings on the same page with hyper communication and a lot of meetings and all of that. But of course, sometimes it's not possible and it becomes adversarial and they all need to hire their own attorneys. And that's typically when I'll step out and refer it to an attorney that does litigation. So in this case, I had to refer Cindy's nephew to an attorney who does litigation, and he spent around $75,000 or so fighting with his cousin over his aunt's estate. So that is why we want to make sure that it's funded. We want to make sure that it's done correctly because we want to avoid that type of turmoil. We want our wishes to be honored. Mistake number 4 is owning property outside of a living trust. And this is for so many reasons. Number 1, you can have, 4 people on title, and at one point, all 4 people are going to pass away. So eventually a probate is going to be needed. A question that I get asked a lot, and I notice that there's a lot of professionals in the room tonight, and so I'm assuming that a lot of you have likely gotten asked this question too. But the question is, can I just put my daughter on title with me? Can I just put my son on title with me? I trust them so much. If something happens to me, they'll already own the house and it won't be a problem. And I often tell clients that it very likely will be a problem. In fact, this is what happened in my own family. As I was mentioning at the start of the call, the reason that I became an estate planning attorney is because my grandparents, all they really had was this house. And they had no idea about estate planning, didn't speak English. And so to avoid problems or issues, or to avoid probate, really, they added my aunt to the title of the home. So when my grandparents passed away, she was the sole owner. My dad and his sister had conflict over how to take care of my grandmother. And for whatever reason, and I'm sure she had her reasons, but my aunt kept the house and didn't give my dad 50% of it, even though verbally my grandparents had said that they wanted everything to be 50-50, for many years. So it has the potential to create a lot of conflict. Not only that, but if I'm on title with my dad and I get sued or I get into a car accident or God forbid I get divorced, now it's going to open my father up to a lot more problems as well. And then the other reason why this is a big mistake or a big problem when people put their kids or niece or nephew or friend on title as a form of estate planning is because of the tax issues that it creates. Number 1, the issues that it creates with capital gains. So if my dad bought a property for $10 and now it's worth $1 million and I inherit it through a trust, for example, then when my father passes away and I go to sell that property, I'm going to get a step up in basis. So I'm going to be treated as if I purchased the property on my father's date of death for $1 million, 0 capital gains taxes. But if my father put me on title and when he died, I was already the owner and it wasn't an inheritance, then if I try to sell it once my father passes away, I'm going to have to pay capital gains taxes from the $10 that dad paid for it to the $1 million that it was worth on his date of death. And then the other issue that has to do with taxes and has become more of an issue as of late are property tax issues when clients add or remove kids from title because of a newer law called Prop 19 that became effective in 2021. This changed the parent-to-child rules as it relates to property taxes, and it had a huge impact on the taxes, especially for income properties that were owned for a really long time. And so to give an example for those of you that are not familiar with Prop 19, the best way to explain it is by way of example. So this is a really quick example. John and Sue own a home worth $1.5 million. That's the fair market value. But they're so lucky, they're only paying $2,000 a year in property taxes because they bought the home many, many years ago and it's assessed at $200,000. They both pass away and leave the home to their only daughter, Cindy. Cindy will keep paying $2,000 in property taxes regardless of whether Cindy lives in the home. So this is the old law. This is before the change, before Prop 19 became effective in 2021. The 30 years prior to 2021, this was the law. John and Sue were good investors. So on their same street as their primary home, they bought a rental. It's the same house and it's also worth $1.5 million. But again, they bought it around the same time as their primary. So they're only paying $2,000 in property taxes a year because it's assessed so low. They pass away and they leave the rental to Cindy as well. Cindy can rent it out and she's going to continue to pay the $2,000 a year in property taxes. So you inherited your property, your parents' property tax basis. And if it was a parent to child transfer, there was no change in the property taxes when a child was added or removed from title. But now this is the new law. So same facts, John and Sue own a home worth 1.5 million, but they're only paying $2,000 a year in property taxes. They pass away and they leave it to their daughter, Cindy. If Cindy lives in the home and she makes it her primary residence within 1 year of her parents' date of death, and she files the appropriate paperwork, she gets to keep her parents' low property tax basis on their assessed value. So 200,000 plus a million. So it's capped at a million plus the assessed value that's not reassessed. So Prop 19 lets her protect the property taxes on 1.2 million. But you might remember that I said that John and Sue's primary home is worth 1.5 million. So there's a slight difference of 300,000. So perhaps the taxes on the primary home, if Cindy lives in it, are going to go from maybe, $2,000 to $5,000 a year. But that's obviously not a big deal, because if Cindy doesn't live in the home or she does not file the proper paperwork, then the taxes are going to get reassessed to the fair market value, and they're going to jump to around $18,000 per year. And then there's no exception on commercial properties, on rental properties, or on vacation homes. So they will get reassessed to the fair market value. So what we have seen in my office is that many times folks will add a child to title. Maybe they get a scary diagnosis and they just want to make sure if something happens to them that one of their kids is on title. And then 6 months later, they will get a supplemental tax bill, and it's just a mess to try to undo it or to appeal it. They typically have to hire a property tax attorney that specializes in that. So we want to avoid that by just helping people be educated on the topic and know that there's definitely benefit in doing it the right way and not doing this shortcut, if you will. Mistake number 5 is not planning for incapacity. Definitely so many people come into the office and they're thinking primarily, if I die, if I go on vacation this summer and something happens to me, I want to make sure that my assets go to my family. But many folks become incapacitated and they have nothing in place. And I've done so many calls with folks who are trying to pay a mortgage for their sister who had a stroke and is incapacitated, or whose mom became incapacitated and they don't even know where they bank, let alone do they have the power to act on their behalf. So when this happens, our family has to go to court and file what's called a conservatorship for us. And a conservatorship is an expensive, long, and super invasive process for the person that is trying to be your conservator. They have to disclose a lot of their own finances, and the court has to be okay appointing them. In fact, Jay Leno, which I'm sure a lot of you on the call know who Jay Leno is from The Tonight Show, he has been married for 30 plus years, and he's very well known for having a lot of property, a lot of cars, and a lot of money. But he and his wife apparently only have wills in place. His wife recently became incapacitated, and he had to file a conservatorship with the LA Superior Court in order to make decisions for his own wife, because she had various accounts that were only in her name. Can you imagine, with all of the assets that they have and not having a power of attorney? So really important that any adult, really, even my 18-year-old daughter has powers of attorney in place. She has no money, but if God forbid she became incapacitated, I would want to be able to talk to Medicare and Social Security on her behalf and sign legal documents on her behalf and sue someone on her behalf if it was needed or appropriate. We probably want someone to be able to pull money from our 401k if that's what's needed. All kinds of decisions. Basically, do anything that you can do if you're incapacitated without having to go to court. Also, really important that our trust covers incapacity provisions and says that whoever's pulling our wagon is going to be able to manage the trust assets while we're incapacitated. We also want to ensure that we've defined incapacity. So in many estate planning documents, it says that two doctors or one doctor have to write a letter saying that we're incapacitated, but we want that to be really, really clear. And then we also help clients with medical powers of attorney, which I tell clients are super important because that's typically where arguments or disagreements will start, right, at the hospital. So we want to say, document, or let it be known who's going to make medical decisions for us, if we want our life prolonged, if there's no hope, if we want medication for pain and suffering, like morphine at the end of our life, and if we want artificial nutrition and hydration when we're no longer getting any treatment and we can no longer eat or, or swallow on our own. So these are things that tend to cause conflict and problems, especially amongst like adult siblings, because it's super, super stressful. So we just want to make sure that we have that outlined for them. A few years ago, more than a few years ago, maybe like 7 years ago or so, I helped a woman who her partner became incapacitated. They were both in their late 50s. They had been together for 15 years. He had a stroke and became incapacitated. All of the accounts were in his name, and he did have her as the beneficiary or as the POD, payable on death. But remember that beneficiaries don't solve all of our problems if, number one, the beneficiaries are minors, or number two, if we become incapacitated. Because in this case, she was the beneficiary, but he was hospitalized, had a stroke, he was still alive. So the bank was not going to give her access to the money. He actually did have a power of attorney in this case, but he had named a sister who he had not spoken to. None of his family had spoken to in years. So the girlfriend, Susie, she had to open or start a conservatorship for him. And thankfully, all of his family agreed, and they agreed that she should be nominated as his or assigned as his conservator. The problem is that they were living in Irvine for his work. This client's partner was an engineer, and so they were living in Irvine for his work, and she wanted to take him back to Arizona. That's where their support system was, where their friends were, where they were from. And so it took more than a year and a half or so for the two courts to talk to each other and for the court here to approve the jurisdiction of the case being moved to Arizona. And this is all something that could have been avoided with a power of attorney, because my power of attorney says that your agent could move your domicile. They can sign your name. They can enter into caregiver agreements. Sometimes they could even take assets out of your name if, for example, that would be best to help preserve the assets, like to help you qualify for Medi-Cal and things of that nature. So we definitely want to make sure that we plan for incapacity because it could be a really stressful and hard time for our family. And then this topic, the difference between Medicare and Medi-Cal, I'm sure many of you on the call already know, and it could really be a topic in and itself, but I do just like to touch on it a little bit. Paying for long-term care is an issue for a lot of people because on average, it costs around $5,000 a month when someone needs long-term care. And I would say what I've been hearing from clients lately is $5,000 a month would honestly be cheap for long-term care. The mistake that we see is that many clients believe that they have to get their house, their primary residence out of their name or transfer everything to their kids in order to qualify for Medi-Cal. There's really numerous ways to qualify. And then backing up one moment, the difference between Medicare and Medi-Cal is Medicare, we don't have to qualify from a needs-based perspective. So as long as we've worked and we have sufficient Social Security credits, when we get to age 65, we're going to qualify for Medicare. And it's really just a form of healthcare insurance. But with Medicare, if I'm on Medicare and let's say that the provider that I'm with is Kaiser, and then I fall and I break my hip and I only have Medicare, and now I can't cook and I can't bathe myself and I can't get around on my own and I need care, then Medicare is not going to pay for that. I would either have to have an insurance policy, I would have to pay for it out of pocket, something like that. So that's where people become interested in qualifying for Medi-Cal because Medi-Cal will pay for that. But then sometimes people believe that they have to take all their assets out of their name, and that is not necessarily true. Medi-Cal is an income-based test, and so they're going to look at how much income we have, and then anything over, like, let's say for easy numbers, $1,000. If my dad's income was 4,000 and poverty level is 1,000, then he would have $3,000 extra, and that's my dad's share of cost. That's what he has to pay before Medi-Cal will pick up the bill, right? So sometimes clients do have like a rental property or something that's creating more income for them that maybe needs to be transferred to a Medi-Cal trust, an irrevocable trust that may or may not help them qualify for Medi-Cal. It depends on the situation. But I think the bottom line is that it's really important to get legal advice as soon as someone realizes that they need long-term care and it might be a problem down the road. Also, there's this very, very common misconception that if folks do qualify for Medi-Cal, then when they die, the house is going to be taken away from their kids. And that is not true. I have it actually saved. I speak Spanish and I have it saved in English and in Spanish. So I can show clients that the law changed January 1st, 2017, where now Medi-Cal can only recover assets that go through probate. So if the assets do not go through probate, for example, if they're in a trust, then Medi-Cal cannot file a reimbursement claim. So the assets will be protected. So that's one part that is good and that's solidified. The other part is like how sometimes people struggle to qualify for Medi-Cal and how we can do that. And the big mistake is when we just start taking assets out of their name in hopes that that's going to work without getting legal advice. Mistake number 6 is not updating beneficiary forms. So many clients come into the office and they have their ex-spouse, a predeceased spouse, or no beneficiaries at all. There was actually a recent Forbes article that talked about a woman who separated with a man in the early 1980s, and she recently just inherited his $1 million IRA. So all of these years, she remained the beneficiary, even though they haven't been together since the 80s, and she inherited his account. So we want to make sure that we update our beneficiaries. We also want to make sure that we don't have children as beneficiaries, so minors, because when we do that, then it's going to go through probate anyway, right? Because Fidelity, Schwab, they're not going to write a check to a 6-year-old or to a 10-year-old, and then it's all going to go through probate anyway, because they're going to want to see a court order that says who it goes to. So a much better plan would, instead of making the beneficiaries my kids, would be to make the beneficiaries my trust. And then that money goes into the trust, and then it could be used for the beneficiaries. Mistake number 7 is not planning for remarriage protection. And I guess the true mistake is not making informed decisions about remarriage protection. So this looks a little complicated, but it's essentially the notion that if I die on my way home from work tonight, my 50% of what my husband Steve and I have together, my 50% is going to come out of the wagon or out of the trust and go into a bucket. And that bucket is an irrevocable trust. Why? Because I want to make sure that if something happens to me, my husband can't inadvertently or intentionally, I hope not intentionally, leave my 50% to his new wife or his 25-year-old girlfriend, right? I want my 50% to be protected for my kids. No 25-year-old girlfriends. So there is a way that we can do this to ensure that it's protected. Now, I've also worked with many couples that have been married 40, 50 years, and they're not worried about that at all. And they say, if I die, my husband can have it all, my wife can have it all. I don't care what they do with it is their business. And that is an okay plan too. But we want to make sure that we know how we're doing it and making informed decisions, especially if it's a blended family. Because many clients have said, oh, well, like we were married, so our attorney just gave us a default plan. We don't even know what it's going to look like after one spouse passes away, and we want to make sure that we know. Mistake number 8 is another topic that I swear to you could be its own presentation, and I don't want to keep you guys here too late. But it is probably the most important decision that clients make when they put a trust together, and that is who's going to be their trustee. Many times clients pick, their oldest child or one of their kids, and sometimes it's not the best option. Sometimes it works out great, But if our kids already don't get along, or if our oldest child is on a little bit of a power trip, then they might not be the best person to be the trustee. Sometimes it's better to have your brother or your sister or a neutral person do it, especially if one of the kids might take on a little bit of a power trip or not want to give accountings or might want to try to stay in the house and not pay rent. And these are all things that create a lot of problems. So many times with the trustees essentially become our client when our clients pass away. And so we're helping them, we're guiding them, making sure they know what they need to do, and sometimes I'm having to remind them that yes, you're in charge. Yes, you get to make the decisions, but you also have a lot of responsibility to your siblings, that you have to keep them informed, that you have to do what's in their best interest. And if we're going to keep working together, then we have to do things fair and by what the law says. And I think that's really important because it's also key to avoiding conflict. Mistake number 9, and we're almost to the finish line. Mistake number 9 is leaving assets outright to kids or heirs. So with a trust, we could provide protection from lawsuits, creditors, and divorce for our children. And that is huge because in a state like California, it's really hard to get our own asset protection from lawsuits, creditors, and divorce. And a really good example of this is Ted Kennedy. I don't know if anyone on the call has ever heard of Chappaquiddick, but in 1969, Mr. Kennedy got into a very famous car accident called Chappaquiddick. He drove off of a bridge and he was able to get himself out of the car, but unfortunately, the woman in his car, she drowned and she passed away. Her family sued Mr. Kennedy, and Mr. Kennedy was pretty young himself, so he didn't have a lot of money. But a few years prior to the accident, he had received a multi-million-dollar inheritance from his grandparents. But the inheritance was held in trust. So if Ted wanted something or he needed something, he had to go to the trustees to get it. So because it was set up that way, it was protected because, of course, the trustees were never going to say, oh, yeah, here's the money you need to pay this lawsuit. Had the money been sitting in Ted's name, had his grandparents not had a trust, or the trust said, hey, Ted, when we die, we're leaving you $5 million and you can do whatever you want with it. Go ahead and put it in your account at Wells Fargo. Then it would have been up for grabs. But because it stayed in the name of his grandparents' trust and it was only given to him as he needed it, it was protected. And that's the same kind of asset protection that you can give your kids or your grandkids by having a trust, which is pretty neat because again, in the state of California, it's really, really hard to get that protection. Mistake number 10, and this is our last one, is doing it yourself and or procrastination. The fill in the blank documents, it's not even just the documents. Sometimes it's that clients don't understand what they're being asked. And so that is a problem, like when they're doing, these online options. But the other issue is that many times they're not executed properly. We're working on a probate right now where I opened the probate, I filed the will, and actually the client wanted to take the will for his stepfather to the courthouse on his own. So he dropped it off, and then the judge said the date on page 1 and the date that the witnesses signed don't match. So I got with the client and I was like, what happened? Did dad sign any other wills? And he said, well, yeah, he had another will. Here it is, but it had no signature. Well, the gentleman had signed a will years prior, so like in 2011. And then when he wanted to change it in about 2016, he just took the signature page from 2011 and attached it to the new will. And so obviously the new will is not properly executed because it wasn't witnessed in front of 2 witnesses. So that creates a big problem because they say different things, right? So, and his intent was probably the 2016, but he didn't do it right, unfortunately. So that and procrastination, as you can likely imagine, I've talked to many folks who have said, oh, my mom and dad, they planned on doing this for years. They talked about doing this for years, and then they never got around to it. And unfortunately, that just creates a really expensive and really stressful situation when they pass away. So yeah, that is all that I have for you guys tonight. Thank you so much for listening. And I'm sorry that I went over on time a little bit past the 45-minute mark, but I'll pass it back to Armando and I'm happy to answer any questions that you guys might have. And again, thank you so much for coming.
Yeah, do y'all, anyone have any questions? You can put it in the chat, and I'm gonna put in the chat again if you want to schedule a time to connect with Alex. It'll be there. Edith asks, what is the cost?
Yeah, so it definitely depends on the situation. For some folks, we only do like powers of attorney, and that might be like a $500 thing. If we're helping a client with a Medi-Cal trust, that might be a $5,000 or $6,000 thing. But on average, a trust-based plan is around $3,500 or so.
Awesome. Any other questions? All right. In the case of Ted Kennedy, could he have been the trustee and still have the same protection? That's a good question.
Really, really good question. No. So him being the trustee would have significantly watered down the asset protection because, of course, the judge would have said, well, you're the trustee and you're allowed to distribute to yourself. So in that situation, if a client, for example, has two kids, I will tell them better to name the two kids and say that they unanimously have to agree in order to make a distribution. So then if one child gets into legal problems, they can't make a distribution to themselves unless their brother or sister agrees to it. But that's a really good question. So no, that would have definitely watered down the asset protection.
All right, Edwin. Yes, Edwin, there's a recording of this. I will send it out in an email in the next 24 hours. So look out for it and you can watch it if you want to watch it again. Art says if we have a trust and I make additional purchases afterwards, can we just write a letter, have it notarized, and will automatically be added to our trust and be valid?
So if you make additional purchases after you do the trust, for example, if you buy another property or you open additional accounts, you actually don't need to amend the trust because you can just transfer those accounts or that property to the name of your trust. So any additional purchases, as long as you do it in the name of the trust or you make the trust the beneficiary, depending on what kind of asset it is, you don't need to amend the trust document itself. You're going to want to amend the trust document when you want to change the trustees, when you want to change the beneficiaries, when you want to change a substantive provision of the trust, but not just to add or remove assets. And I think this is one of the key benefits of working with an estate planning attorney and someone that you feel comfortable with and an office that you feel comfortable with, because many times clients will call me and say, hey, Alex, I purchased a timeshare, or I bought a boat, or you know what, that house that I was going to leave to my daughter in the trust, she's been paying the mortgage, so I just put it in her name now, right? What does that mean? Do I have to amend the trust? But someone that you can come back to and ask these questions, because assets change, family dynamics change, life changes, and laws change over the years, right? So we want to make sure that we keep it up to date.